Greetings, wonderful people, men and women of good conscience and lovers of freedom all over the globe. This is coming from the desk of Nicky Bobby. We just want to bring to you the first-hand information of what's happened today as regard to the court hearing of Mazi Nnamdi Kanu that was attended by so many people, as well as the barristers of the indigenous people of Biafra. Barrister Aloy Ejiofor, Barrister Ifeanyi Ejiofor, Barrister Michael Zekobi, and others that are attended. We are bringing you the first-hand information so that you will hear from the horse's mouths what really happened, what Barrister Ifeanyi Ejiofor is going to give us here is to give us the exact information first-hand of what's happened. We really want to hear the first-hand information, and we are inviting Barrister Ifeanyi Ejiofor. Barrister, over to you.
Thank you so much for having me on your platform. I'll be as brief as possible because I have other compelling things to attend to. But we need to clarify our people about what transpired in court today. First of all, let me use this opportunity to make this clarification regarding the rescheduling of the case from 11th of October to today. So you understand that when we file this appeal, in view of the nature of the appeal and the need to hear the matter speedily, we have an application we'll file under what they call fast-track rule of the Court of Appeal. So for accelerated hearing of this appeal and also for time abridgment. So, and also have a letter we wrote to President of the Court of Appeal requesting for the matter to be heard, giving a expeditious hearing. So, and we were given a date in October then. Within that intervening period, the federal government filed a respondent brief with an application for extension of time to regularize what they filed outside time, allow under the rules of Court of Appeal. So, and also we replied immediately. So I believe His Lordship, during the period they were looking at the file and observe, we have an application for accelerated hearing of the matter brought on portion to fast-track rules of the for the Court of Appeal. So that was basically informed why the matter was brought forward. So, and the appeal was heard today. If you're in court today, if you have opportunity to be inside the court, of course you've seen things yourself today. So the appeal was heard on the merit. So let me also correct, because my attention was also adverted to publication made by the BBC to the fact that one application was filed was struck out, and that was where they stopped at that point. So it was an application for accelerated hearing of this appeal and time abridgment. They having so much to consider it on the merits. The court said, by virtue of the fact that briefs have been exchanged and parties are now before the court, that application has overtaken by event, because what actually we are asking the court to do has been done in practice. We are asking the court to hear this matter expeditiously and also to abridge time, provide under the rule for appeal to be heard. So having brought that matter forward from October 11th to September 13th, the court has technically granted an application, and portion to which it was, at least on the record of the court, moved and struck out, applied to be withdrawn. So the court had the application on the merit, and the court was very emphatic about His Lordship's disposition to deliver judgment in this case as quickly as possible. That was first observation the court made. The court is also not mindful of the fact that under the Court of Appeal rules and also extant laws, that they have 90 days from today to deliver judgment. But the court was very emphatic that this appeal, the judgment on this appeal, we will not be surprised that they ask us to come back in next if we receive a notice from the court in the next 14 days for them to be delivered. The court observed that. So, and they were emphatic that that appeal judgment will be delivered as quick as possible. So, my happiness today is that the argument was exhaustively canvassed on the merit. Adoption was marvelously adopted, done by the next SAN. All born issues of laws and fact and weird clarifications are needed were made in open court. So, and it became very clear to the court about what brought us to the court, while we are challenging the 7-count charge bill returned by the Federal High Court. So, and also The issue of extraordinary rendition of Onyeduma's Nnamdi was also discussed today. And thankfully, for the first time, the federal government, ably represented by the council from the AG Federation's office, admitted before the court that Nnamdi was actually kidnapped by the federal government in Kenya and brought here to come and face trial. So obviously, I believe that by the time he was making that submission, he did not understand the implication of that line of argument, but he has made a point. And also, furthermore, he also admitted before the court today that they've amended this charge 7 consecutive times. Even the court of it was worried. Say, in open court, you're admitting. You're admitting before this court that they amended charge 7 consecutive times. What are you trying? What are you trying to? What message are you passing to the public? So if you're amending the charge, and respondents are filing applications probably for one reason or the other, you won't blame them because you caused it. These are things that were sorted out in the open court today. So, and you should also understand that part of fundamental grounds we are in the Court of Appeal for the lordship to determine was for the court to determine the issue of extraordinary rendition of Mazi Nnamdi Kanu in flagrant violation of Section 15 of Extradition Act, LFN 204 of Nigeria. Because at the point he was abducted in Kenya, there are laid down rules under the law through which process he was brought into this country. Also, don't forget the fact that Nnamdi Kanu never traveled to Kenya on his own. No. Nnamdi Kanu never traveled to outside the country. There was a visible attempt to eliminate him sometime on September 14th, from September 10th to 14th of September 2017. And by sheer act of providence, he escaped being killed. Of course, evidence abounds. Over 28 persons, innocent and unarmed civilians were murdered in his home by the soldiers who were there to kill him. So now, all the facts relating to what transpired in his home on 14th of September precisely was also captured in affidavit evidence. Evidence will also present before the court. Now, he's not in Kenya. Before you talk about bringing him to this country, there are laws that says he must be subjected to extradition proceedings. That's number one. Or the Kenyan government must have consented for him to be arrested and brought to this country. But as I speak to you, let me mention this to you. We have a process filed by the Kenyan government in the matter, an action initiated against the government of Kenya for their role in the abduction, kidnapping, and extraordinary rendition of Nnamdi Kanu to Nigeria. We have a process before going on with their court, which they maintain, as I speak to you today. Kenya government maintain from record available to them that Nnamdi Kanu is still in Kenya. I hope you understand what I mean. That is still in Kenya. So apparently telling the world that they're not part of part of the violent manner in which he was abducted and brought to this country. It wasn't brought to attention. That they are trying to exonerate themselves. So in that case, so now by admitting before in open court today during submission by a federal government lawyer that they abducted Nnamdi Kanu and brought him here to face justice, that they've not committed any offense, we are talking about violation of international laws, to which Nigeria is a signatory to. It's a signatory to the laws. So these are what we are talking about. So, and that was admitted in open court today by the lawyer to the federal government. So, and remember, don't forget that this is the first issue listed for his lordship to determine whether the manner in which Nnamdi Kanu was adopted in Kenya and subsequently brought into this country, whether in that manner, whether on the face of that action taken by the federal government, whether he can face the trial, he can face the charge amended, some can charge amended as stand today, amended against him, filed against him. And the answer is no. Because Section 15 of the Extradition Act is clear that even if the person is lawfully brought into this country, that section is in a stage where someone has passed through the process of extradition proceedings and subsequently brought into this country lawfully. That even when he's brought into this country lawfully, that the person will only face the charge for offenses allegedly committed before he escaped from trial. But in this case, he was not brought into this country lawfully. He was forcefully arrested in Kenya, tortured, before he was also secretly brought into this country. Then now, these actions were taken by the Nigerian government in clear violation of international laws. Right. Now, going forward, the federal government of Nigeria has also amended Terrorism Prevention Act of late, which is now into force. That section 23F of that law, says that in the event of this kind of situation, where a nation of another country is abducted from a different country in violation of standard international laws and covenants, that country in breach of that law, has committed an act of terrorism against that person. So as it stands today, Nnamdi Kanu is a victim of terrorism. So these are part of argument which also have been brought up before the Court of Appeal today. And I doubt, and I'm trying to find out how they're going to escape it. So because the facts speak for itself, and the appellate brief and response brief filed to the fact effect is very exhaustive on that point. And other issues of laws raised that has to do with no prima facie case established before the court, before Nnamdi Kanu, the pro evidence filed before the lower court cannot sustain the bogus charge and allegation against him. If you're in court, when the responding counsel was trying to make a word about pro evidence that the trial has to go on before the court determine whether the pro evidence attached to the charge can sustain it. The court was curious, his lordship was curious to find out from him what led to the striking out of 8 count, out of 15 count original file. And he was beaten up, he was struggling to answer that question. At the end of the day, he came back to simple truth that the pro evidence attached to the charge cannot sustain the charge. And that was the reason why the 8 count out of 15 count was struck out, the remaining 7. And that is why we are in Court of Appeal today, to tell the court, my lord, that even the evidence this people are relying upon has been evidence, statement of witnesses, unnamed witnesses, filed in court since December 2015. That's the only evidence they have before the court in prosecuting this matter. They will not file for evidence. In all these amendments that have been effecting, from 5 count amendment to 7 count, from 7 count to 15 count, before it was eventually returned to 8 was struck out, remaining 7.
Thank you, Barrister, for this clarification and update. And I understand that there are some rumors, or should I say, unclarified situation as regards to the remaining 7 counts charges. I want to know, what is the stand of the Court of Appeal on this? I mean, the 7 count charges, please.
The point, that's why we're in court. That's why we're in court. That the essence of we're in Court of Appeal to challenge the remaining 7 count charge on the grounds listed, on grounds of law, facts, and misleading facts. So, which have argued on the merit by his leadership today. So, the arguments was taken from both sides, and we are with judgment until when judgment is delivered. We don't know what they say about the appeal, but we are strongly and firmly believing that this appeal, will be God being on our side, will be found meritorious, and then can be set free. Thank you.
Great. By nature, humans decide to know. Please, Barrister, we want to know, what is the health status of Mazi Nnamdi Kanu? Can you brief us on that, please?
His health condition is part of the reason why we are in Court of Appeal. Actually, of course, you may have noticed that we have an application for his bail, which we mentioned today before the Court of Appeal. We've caught his lordship in their wisdom. We have the view that since the main case is ripe for hearing, which the main appeals, that it's better for us to go into the battlefield and sort it out. Then he didn't strike out that application. Then on the day of judgment, if the judgment goes one way or the other, if the government says the 7 count charge remaining are now dismissed, then that's the end of the case, settled. Then the lordship said, okay, this and that happened. Then we can now take application for bail. That will be another option. But now, of that, and in that application for bail, we exhaustively discussed issue of his health. Do not forget that his lordship, Honorable Justice Sinyaku, made far-reaching orders regarding allowing him to bring his own personal physician to conduct independent investigation of his health status. These orders were flouted with impunity by the DSS. Of course, DSS has a history of not obeying court orders. So we have to be aware of them. And that's part of the reason why we're in Court of Appeal today. So he's not being managed. I can't say that his health is being managed by SSS effectively, because they don't have the facility to manage it. Of course, when he was in Kenya, he was subject to all forms of torture and ill treatment. So on account of that, he's still taking drugs today. So it is high time. That's part of the reason why the court ordered that they should allow him to bring his personal physician, his personal doctor, medical doctor to come and examine him. This order has been flouted till date. In fact, a few weeks ago, attempt was made at bringing a doctor that will come and see him, and they said no. They said no. But these are facts before the court, and today, thankfully, it's not Chief Michael Zekome also mentioned to the court that he's sick and need to be treated, need to be granted freed for him to take care of his medical health condition. So because SSI has no facility to treat it. Of course, you are aware about people are aware. It's also in the public domain about the depletion of his potassium content. So these are serious health challenges that need prompt medical and sophisticated medical attention, expert attention. So, and SS don't have such facilities. Right, they've been giving him drugs. They've been on trial and giving him drugs on daily basis and whatnot. So, but we believe that there'll be freedom, that will be victory at the end of the day. We're not relenting. We're not giving we're not giving anything to chance. We are all over the places with them. We're in Court of Appeal. We're in High Court. We have other actions to file against them. So, and I believe God will worship on the face of this earth that Nnamdi Kanu will regain his freedom sooner than expected. Thank you so much.
Thank you. Did the appeal court schedule any date yet?
No, usually when appeal is hard, they won't give you date. They can even come to work tomorrow and receive hearing notice that judgment will be delivered next tomorrow. So that's having their practice. That's standard practice of Court of Appeal. They don't give dates for judgment.
Protocol, the November 14th date is still standing, right?
We still have November 14th on the table, but I can assure you most strongly that something will happen before then. Take it from me.
Barrister, that's incredible. Thank you very much.
God bless you.
Of course, this is an excellent development, wonderful people. You've heard it direct from the mouth of our erudite lawyer, Barrister Ejiofor. Of course, he is the IPOB lead counsel in this issue. We are really happy for this great and new developments. IPOB continue marching and Biafra is going to win. We are looking forward to seeing how everything will unfold. Like we normally say, that it is in Biafra land that all of us have our citizenship. And until Biafra is fully restored, we will not rest. May you remember safe and blessed wherever you may be.